Hello everyone, I'm Lee Pacchia and this is Bloomberg Law on Demand. I'm happy to say my guest today is the Harvey Miller from Weil Gotshal Manges. Harvey, of course, is the well-known bankruptcy attorney who has represented so many of his clients through their financial difficulties, chief among them Lehman Brothers and automaker General Motors. Today we're going to be discussing Title II of the Dodd-Frank Act. It's the so-called Orderly Liquidation Authority. Harvey, thanks so much for coming in today. Welcome to the program. Pleasure to see you. So I wanted to start things off by working off of your recent article that appeared in the Harvard Business Law Review. It talked about Title II of the Dodd-Frank legislation. Not something we've talked about too much on this program is the so-called Orderly Liquidation Authority. What's in that part of the bill?
Title II of the bill really deals with the situation when it's determined that a covered financial company is in such distress that it has to be liquidated. Mm-hmm. So
is it well defined? What's covered?
There are definitions, but I think you have to view this bill, or this act now, as an act which was created by a committee, which may have been designated to design a horse and came up with a camel.
Right.
So it's a very confusing bill. It's a very difficult bill to apply. And I think, as you know, we're still waiting for rules.
Right.
Some of the rules may take 3 years to implement.
Right.
Or adopt.
So looking at this process, how's it initiated? My great bankruptcy professor from law school, who worked for you for some years, Karen Gross, always said that the decision to file for reorganization or liquidation is never a happy moment. Who calls the shots here? Who decides when Title II comes into effect? Well,
it's very interesting. When you look at the Act, it has two parts, Title I, Title II. Title I is the part about trying to avert failure. Mm-hmm. So it has capital requirements and oversight and regulation. Title II is when failure occurs.
Okay.
Now, as you point out, under the bankruptcy laws of the United States, mostly it's a decision by the bankrupt or the debtor.
Sure.
The way this bill is set up, if 2/3 of the board of the Federal Reserve System and 2/3 of the board of the FDIC, in consultation with the Secretary of the Treasury, decide that there is danger of systemic risk for a covered financial company, and after consulting with the President, they can initiate a proceeding under the OLA, the Orderly Liquidation Authority, but they have to ask the company if the company will acquiesce. Okay. And if the company does not acquiesce, then they can go to the district court and ask the district court in a closed hearing to put the company into an OLA. Very cumbersome.
Yeah, it sounds it. Another thing I wanted to know about recourse. What happens if a decision is made in this process that the company or its creditors are not happy with? Can they appeal anywhere? Is it a final decision? You
have to understand, the concept of this Title II of the Dodd-Reform Act is that there is no creditor participation. One of the things that is established under this act is that the creditors and the stockholders of the covered financial institution have no standing. They're out of the ball game.
Do you think it's going to remain that way through the rulemaking period?
It's going to remain that way. I mean, you have to put it in the context of Washington when this was adopted. This was adopted in the frenzy that there will be no more bailouts. There's no such thing as too big to fail. And the taxpayers are paying for these bailouts. We want to make creditors and stockholders liable for whatever it costs. So right up front, this bill eliminates them in effect. So there is no recourse. And once a company is in or under OLA, it's basically a closed process. The FDIC becomes the receiver, and the FDIC is the generalissimo, so to speak. Its decisions are not reviewable. There are no judicial proceedings.
It sounds like the FDIC simply has too much control over this process. How can this be fixed? I mean, who else can be roped in here?
The only way you can fix it, really, is by changing the statute. Generally, rules cannot change the fabric of a statute. And this is what they wanted. You have to understand that. The underlying premise is that we have to move quickly. And if we're going to move quickly, we cannot be bothered with creditor interests. The objective here is to avoid systemic risk. And therefore, whatever the FDIC does, it has complete and unfettered discretion, basically.
Do you think that there's a substantive reason that this change in the law wasn't done under the bankruptcy code?
Well, that's a very hard question to answer, I have to tell you.
I mean,
but
politically, I imagine it's not easy.
I think there was competition between the House Finance Committee under Barney Frank and the House Judiciary Committee, then under John Conyers. And I think Congressman Frank was very anxious to get a bill passed, and he made a lot of compromises. The argument which was made, which an argument might appeal to you, is bankruptcy courts, creditors can come in, they can get up on their hind feet.
Sure.
They can make statements. We haven't got time to bother with them. So when we went through all those arguments, and I was testifying in Congress one day, and there was an undersecretary of the Treasury there, and there was a representative of the FDIC, and I said, well, what you're basically proposing in this resolution regime is a star chamber. Star chamber is a phrase for what the King of England used to have, where nobody could question it. And they basically said yes. And we just don't want to bother with the creditors. And I said, well, there's such a thing as due process. And if you take a case like Lehman, there's $200 to $300 million of creditors.
Right. Do you ever imagine what Bear Stearns or Lehman would have looked like going through this process?
Look, it may be very effective if you have the right people in moving very quickly. But then the basic argument was, well, this gives the OLA the right of speed.
Right.
And I said, well, what are you saying, that you can't get speed in the bankruptcy law? And basically they both said yes.
Yeah.
And I said, well, I have to tell you, we sold Lehman's North American capital markets business in 4 days.
Right.
Do you think the FDIC can do that?
Right. I mean, there's just not enough time to come up with a reasonable valuation of the assets.
Well, depending on the size of the problem, it's pretty easy to make a determination as to whether anybody else would be interested. But in terms of speed, in my experience, you can move as fast in bankruptcy as you can move, as they think they can move under this statute. Maybe faster.
So what's next? We're in the rulemaking period. Where, in your opinion, should the dialogue be set? What should we be what top 2-3 things should people be focusing on to try to make this the most workable solution possible?
There should be some level of transparency, and the rules should provide for that. Some due notice of what is going on, what's happening to the property. There is no provision for that in the statute. It's even very complex as to, it says the rights of secured creditors shall be preserved or protected, I can't remember, or not in any way invaded.
Right.
Yet it talks about the ability to move the good assets to a bridge company.
Right.
And then to finance the bridge company. Well, and then it says that the government, to the extent it provides financing, gets first crack at any return. In fact, there's even a clawback in the statute. Right. Well, does that mean you can prime the secured creditors? They're not sure. They're not sure. So all the rules have to elaborate what was intended in the statute. And that's going to be a very difficult process. Chairman Bear of the FDIC has come out with proposed rules and created havoc. She was criticized for coming out too early. It's going to be a very difficult process. Anytime you have a committee and different voices being heard, it takes a while to get there. And then, of course, the financial lobby is extremely powerful.
Right. No, it's a messy process. Harvey, we're going to have to leave it there for now.
Okay.
Always a pleasure to see you. Thanks
Great
for
pleasure.
coming in. Harvey Miller from the law firm Weil Gotshal Manges. If you'd like to learn more information about what we discussed or anything else happening in the world of bankruptcy or Dodd-Frank, go check out our offerings on BloombergLaw.com and, of course, on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.